Hello, my name is Zachary Smith, and I'm an attorney with Beresford Booth, and I'm going to give a little presentation on inadvertent disclosure of privileged materials in the context of a lawsuit. Why is this important? In any lawsuit or any dispute, there are certain privileges afforded to either side that allow for protection of certain materials. All communications with your attorney that constitutes a privilege that is considered attorney-client privilege. So direct emails, letters, even text messages. And then there's also something called the work product doctrine, which is anything that you create solely for the purpose of litigation is also protected. And disclosure is a term you're probably familiar with, but in the context of a lawsuit, it's what you are obligated to provide to the other side. And an inadvertent disclosure is when you accidentally turn over to the other side something that would validly be considered attorney-client privilege or work product or protected under the work product doctrine, and thus should not have been provided to the other side. But accidents happen, and when this does happen, the consequences can be big. It can be a waiver of that privilege so that other documents that would have been protected also are no longer protected. You can be sanctioned for violating discovery. And as an attorney, you can get in trouble for violating the rules of professional conduct when there is an ethical violation. And most importantly, when you turn over your client's protected documents, it can be an erosion of trust between you and your client. This can happen for a number of reasons, but most commonly, it's a simple mistake. During discovery, let's say this is an example. Let's say defense counsel produces several thousand documents over many decades. And months later, the receiving party who got the production comes across material that on its face, meaning what you can see, appears to be privileged. Either it was clearly marked as a communication from their attorney or a prior attorney or labeled. Either way, it's obvious from reading it that this is probably a privileged document. When you are the person who receives it and makes this realization, you have to immediately notify the person or party who sent it to you and stop looking at the document, stop using the document. If you read 10 pages before you realized it was privileged, that's when you stop. If it only took 2 seconds to determine it was privileged, then you just have to stop looking at it immediately. And you got to let them know, hey, Mr. So-and-so, it appears that in your most recent document production, you accidentally gave us a communication that appears to be between you and a client. What do you want me to do with it? I assume you want me to destroy it. If you are the party who sent the privileged document and you realize that you sent something that should not have been produced, you have to immediately call the receiving party and say, I'm really sorry. This is a mistake. I apologize. Can you please send it back or delete it and confirm once it's deleted? And these other 3 or 4 things that may have been produced as well are also privileged. Can you please delete those? Upon this initiation, either by the receiving party or by the producing party, that inadvertent disclosure has occurred, the receiving party must honor the clawback. And that means they have to destroy it, stop looking at it, return it if it's a tangible item, whatever it is, they have to honor the request, and then they have to confirm with the party that it's been destroyed or returned or deleted. The rules that govern this type of thing, they all work together. There's an evidence rule called the No ER 502B No Waiver Rule. And this rule exists so that when an accident does happen, it doesn't destroy the attorney-client privilege or work product privilege. This privilege can be retained if the disclosure was inadvertent, the producing party took reasonable steps to make sure a mistake like that doesn't happen, and then reasonable steps were also taken to fix the mistake once it did happen. Court Rule 26B6 is the clawback procedure, and that is when you realize that you accidentally sent something that you shouldn't have. You have to promptly notify the person who sent it to that you accidentally sent something. It's actually privileged. You got to sequester, return, or destroy it. And then finally, the rules of professional conduct, the ethical duty of an attorney who receives something that they know or should know. Back to a moment ago when we talked about a document on its face appears to be privileged, you need to notify the sender as soon as you make the determination that you have received something that is privileged. In the context of these disclosures, there's inadvertent and there's negligent. Inadvertent is a mistake. Negligent is a mistake also, but it's less explainable. When dealing with something like this, courts look at everything going on, the totality of the circumstances, to determine whether or not the privilege should be waived. And when it comes to attorney-client privileges, courts will really closely examine. That is not a privilege they are prone to waive or happy about waiving. One of the circumstances that gets examined is the volume of the discovery. If you gave someone 7 documents and one of them is clearly privileged, that's going to be a tough argument to make that it was an accident. If you send over several thousand, like our example, then it gets more understandable how something could have been missed. Reasonable steps that were taken to prevent an inadvertent disclosure, those are not specific to the event. Those are more like, what do you typically do to prevent producing attorney-client privilege material in discovery? Do you have a system? Do you look at it? Does anyone else in your office look at it? Does an attorney look at it? Does only a paralegal look at it? Do you keep a log and track the privileges that you're asserting, which is called a privilege log? And those are things courts will look at. The speed and adequacy of the response is important too. If you have received something obviously privileged and you don't tell the other side until the eve of trial, you're going to be in trouble. If you produced something that is privileged and you realize it, but you don't claw it back for several months, then courts are going to say, well, what took so long? Like a moment ago, I mentioned the privilege log. If you didn't create a privilege log, the inference is that you didn't carefully review everything. And what's typical with these larger productions is keyword searches where instead of looking at every single page and reading every single page word for word, the attorney and the people working on the case will come up with a punch list of words that would likely appear in a privileged document so that they get flagged. And then they review that smaller subset once that search has been conducted. But merely sending a giant production, it doesn't absolve the attorney of the duty to make sure that it is all responsive, non-privileged material that is valid for discovery. Reasonable steps. The preventative measures include several things that I just mentioned. The layered review, having more than one set of eyes go through a production set to make sure there's no privileged documents in there. Privileged search terms, like I just mentioned. Technology, there's a whole host of software out there that can make searching large quantities of documents much easier, provided you use them correctly. And documentation, timely creation of a privilege log. It makes sense to start thinking about a privilege log the minute you start going through any pile of documents that you're intending that will ever get to the other side. And it's just easier to do it that way. Labeling documents that are privileged is extremely helpful. For one thing, if you're receiving a document that has a label on it, that gives a much more credible argument that it was mistakenly kept in, but it was appropriately labeled. If it doesn't have a label, then the other attorney might not see that. And then, of course, with all the technology these days and digitization of everything, scrubbing the metadata before you send it out of your office is always a smart move. With a case that goes back many, many years, you might be dealing with a lot of documents that were scanned in and did not ever exist in a digital form, but were paper somewhere until maybe a county or somebody decided to scan them. And those scans, they can be searchable. It's a little more technologically advanced, but a lot of times they're not searchable. And merely having a large volume of them and not being able to search them does not absolve you of the duty to make sure there's no privilege in there. Um, if you do not create a privilege log at all, it gives a strong indication that your review was not reasonable. And everyone knows that titles of documents and folders are not always accurate. And sometimes a person reading a title many years later may not mean the same thing as the person who created the title. So you cannot rely only on titles. When you are the attorney who accidentally produces something you should not have produced, immediate action is required. You have to tell the person who received it, usually opposing counsel, in writing immediately, identifying what it was you gave and the privilege you are claiming. You have to request that it be destroyed, returned, or sequestered. You have to keep track of everything that you've done, the emails, the timing, and if needed, a declaration. If the lawsuit is going already and a document has been used somewhere in the course, then you got to stop relying on it until the court makes a ruling. And you got to look inward. You got to look at your own office and figure out how this happened so that it doesn't happen again. Back to the timing. It is critical. There is a case right there, Sitterson v. Evergreen, where delay, even weeks, can waive privilege. Once you know, you need to act. I'm going to take the example from earlier. I'm going to flesh it out a little bit more. So in that example, a big bundle of documents were received. Plaintiff's counsel looks through them, comes across something probably privileged, tells defense counsel, hey, I think you probably didn't mean to produce this. Defense counsel promptly responds and says, yeah, you're right. Thank you. Thanks for the heads up. Please destroy that folder or those documents. And by the way, I've looked at everything else and there's nothing else privileged in the balance of the production. Plaintiff's counsel honors the clawback request, destroys his privileged material, and advises defense counsel, who confirms receipt of the acknowledgement. Many months later, during the course of litigation, plaintiff's counsel uses a document that was contained in the production but was not identified by defense counsel as an exhibit to a brief. At no point during this entire process has defense counsel ever created a privilege log and provided it to plaintiff's counsel. Upon learning that plaintiff's counsel has used a document as an exhibit, defense counsel makes a motion to strike that exhibit on the basis that it was privileged and the plaintiff's counsel should have notified him. This creates a strange situation. Do plaintiff's counsel always owe a never-ending duty every time they come across something that might be privileged, even in situations where defense counsel has affirmatively represented that there is no more privileged material in the documents they produced? Rules that apply to this example are based on how the court will look. The court will decide if the privilege for the exhibit was waived. They will look at the totality of the circumstances. They will examine the reasonable steps that were taken or not taken. And the three-part test is right there in ER 502. Was the disclosure inadvertent? Were reasonable steps taken to prevent it from happening? And were reasonable steps taken to promptly rectify it? If the producing party did not take reasonable steps to prevent or promptly correct the disclosure, chances are the privilege will likely be waived. And one of those reasonable steps is the existence of a privilege log. It is really hard, I think, to look at a judge and say, this was an inadvertent disclosure when you have been notified of privileged material being produced. You have affirmatively represented that there are no other materials that are privileged that were produced, and you also have never created a privilege log. If you have any questions about this topic or are anticipating litigation with a large volume of production, feel free to give us a call. Send me an email, call the office. We'll get you set up and tell you what we think. Thanks a lot.